I've been made to understand that the original was filed somewhere else within the ballistics section, and they're still looking for the original, my lord.
Yes, sir. Mr. Mgomezulu.
My lord, I was told that Mr. Advocate Mnisi wishes to address the court.
No, you must start. You're the first one.
My lord, in relation to the application by the state, I'm still under the impression that there's a provisional order that has been made in respect of that document. That if the original is not brought, it will be expunged from the record.
Yeah, quite. But this is a second document. You said it's 0002.
That's correct.
Not 0001.
That's correct.
So the provisional order related to 001.
That's correct.
Are you with us, Mr. Mgomezulu? I'm saying the application relates to 00002.
That's correct.
Yeah, not that one-page document.
Yes, correct.
That the application is about 29 of those pages. Hello?
That's correct, my lord.
So what's your response, sir?
On my side, my lord.
Yes, yes.
My lord, is the same position. I have no objection if the document can be provisionally
Admitted.
Yes.
Okay. Mr. Ramsepeli?
Indeed, my lord, if the document is provisionally admitted pending the original being procured, as the court places.
Yes, Mr.
Same view.
Same view. Mr. Maman?
My lord, I also share the same view.
Okay. And Mr. Mshololo?
Yes, my lord. Same view, my lord.
Okay, the document 00002 then is provisionally admitted pending the production of the original document.
Thank you, my lord.
Yes. Okay. Yes, Mr. Mnisi.
My lord, this is something that has got nothing to do with the proceedings per se, but it has a bearing on the proceedings themselves. This relates to the condition in which Mr. Nkandla is held at Kochimampuru prison. I must be very sincere, my lord, that it is bugging me to an extent that I'm no longer able to concentrate on the business of the day, which is to conduct this trial, because this is a collateral issue. It being collateral, however, as I'm saying, there's got a direct bearing on this case itself. The court will recall that in May, Mr. Nkandla, through me, of course, informed the court that he's being held in solitary confinement, and the court made an order that the prison authorities should come and explain themselves out here. And before court, Mr. Koza came, accompanied by a certain Mr. Krebengo, and there was also a legal advisor who now I've forgotten her surname. And they made an undertaking. In fact, Mr. Koza then indicated that he was not aware of the incarceration circumstances of Mr. Nkandla, but now that he was made aware, he will go and investigate what is happening, and then he will come and report. Because Mr. Nkandla was complaining about the fact that he has been held in solitary confinement since his arrival at Kochimampuru in 2020. And he has not been informed of a reason why he has been held in solitary confinement for 4 years. He's telling me that the procedure that he has been informed of by the prison authorities for a person to be held in solitary confinement is when the person has been sentenced and is serving in sentence, re-offense in custody. As a penal provision, they might then decide to take him to a solitary confinement. But this has not been the case with him. And even so, when a person has been held, has been sentenced internally, as an internal measure, a punitive measure, to go and spend some time in solitary confinement, the maximum period that such a person can spend in solitary confinement is up to 18 months. It's up to 18 months, my lord. Then the law says he should be released. But with him, he has been in solitary confinement since 2020 when he arrived at Kochimampuru prison, which is almost 4 years now. He has been consistently trying to siphon reasons, to get reason from the prison authorities about this continued indefinite detention in solitary confinement to no success. Fast forward, Mr. Koza came here, and then he made an undertaking that he would go and investigate the circumstances relating to him being held in solitary confinement, and he will report back. He hasn't. I took it upon myself, my lord, to take the matter up with JICS, which is the Judicial Inspectorate for Correctional Services. I wrote a representation on behalf of Mr. Nkandla and alerted them to the plight that Mr. Nkandla has been subjected to. They sent out a certain gentleman by the name of Mr. Maswangayi to go and investigate the issue. However, in the course of investigation, it is procedural that they need to get a report from prison authorities. According to Mr. Mncube, Mr. Maswanganye had an interaction with Mr. Kebengu, the gentleman who accompanied Mr. Koza here. According to Mr. Mncube, the report that he gets from Mr. Maswanganye, because Mr. Maswanganye firstly consulted with Mr. Mncube to get the background of his complaint, and then Mr. Maswanganye then approached Mr. Kebengu. But Mr. Maswanganye, when he brought back the report to Mr. Mncube, he told him that Mr. Kebengu is avoiding him and he does not want to talk about his the circumstances and condition of his incarceration at Hoshima prison. They are therefore unable to process his representation. Now we are at a position, in fact, in early August, I think Mr. Baloyi sent me a WhatsApp that came from Mr. Kininda, trying to explain the circumstances of what could be happening. I'm not so sure whether I need to read it on record, but part of what he's saying, he says there were some issues of security concerns around Mr. Mncube, and he was at the same time accused number 2 had requested to be accompanied to a bank and stuff like that. So he's saying he does not know what is it that they are planning. Well, whether that is the case or what, it is neither here nor there, because all that I know is that Mr. Mncube is serving a sentence at Hoshima prison, and he's under the custody, he's under the guardianship of the prison authorities. I cannot fathom any reason why should Kininda, being a member of the South African Police Services, which is SAPS, would then have to go and interfere with the procedural, the processes and protocols of how inmates should be kept at correctional services. But fast forward, my lord, we are now at a position where I find it very difficult to get instructions from Mr. Mncube. It has been almost 4 years that has been held in solitary confinement. The system is systematically lynching him. This is a lynch. Each time he's supposed to get an answer of the reason why he's been held in such a solitary confinement for such a long time, they're attacking and diving. That is a Stalingrad approach. They know that Mr. Mncube has got no money. He cannot afford to fight his legal battles elsewhere. He cannot afford to have an attorney to bring up a substantive application to challenge this gruesome conduct by members of the correctional services. They know very well that he does not have that, and they are exploiting that very same situation. And the only recourse that Mr. Mncube has, it is this court. If this court is serious about upholding the rule of law, I'm going to urge this court to get into the dynamics and find out what is actually happening with Mr. Mncube. Because at the end of it all, this has got negative effect on what is termed a fair trial on Mr. Mncube. Now, I know the court that is going to tell me that no, but I cannot interfere, and that will not be true, because Section 173 of the Constitution reads as follows, and I'm going to read it to the court. Section 173, my lord, of the Constitution says, the both letters, the topic is inherent power. The Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa, each has the inherent power to protect and regulate their own processes and to develop the common law, taking into account the interest of justice, my lord. Now, the question that we basically need to ask ourselves is it really in the interest of justice, where a person is facing such a massive trial, with such massive allegations against him, to be further subjected to this kind of a lynching? It surely can't be in the interest of justice, because they know that being held in a solitary confinement has got a damaging effect on your psychology. It psychologically defeats you, it psychologically drains you, it psychologically renders you vulnerable. At the end of it all, you're supposed to follow the trial, what is happening, you're supposed to formulate your defenses. In the circumstances in which Mr. Mncube is being held, my lord, it does not have that advantage, because they're psychologically draining him. This is a systematic lynching on the psychology that Mr. Mncube should be applying in the defense of his case. And that also affects me, my lord, because each time I consult with him, he brings up this, he brings it up to me. So I have to fight two fronts. Number one, I have to concentrate on this trial, on the merit of this case, and number two, I have to try and sort out what is supposed to be attended to by members of the correctional services, my lord. I am therefore going to implore this court, and very sincerely, that the court should once again consider to call those members who were here in June to come and explain themselves out. Failure which, my lord, I will be left with no option but that as we resume, because today is the last day, as we resume on the next semester, I'm going to take a week or two from the court's time to try and attend to Mr. Mncube's plight. Because in bringing a substantive application, I'll have to go and get an attorney who will be prepared to do this matter on behalf of Mr. Mncube pro bono. I'll have to go and sit in the office and draft papers on an agent basis to challenge the decision or to challenge the DCS. To give us, in fact, to bring an application to compel them to give their decision. Then thereafter, having received their decision or their reasons why they're constantly holding him in custody, in solitary confinement, and then to bring an agent application in that regard. I will not be able, my lord. I need to be very sincere. I will not be able to do that while at the same time I'll have to proceed with this case. Otherwise, something must be done and be done very urgently. But as I've said, this court has got an inherent power to investigate. Not really to say this is what DCS should do, but at least to get to the bottom of this.
Okay.
Thank you, my lord.
Yes, Mr. Balawi, are you responding?
As a court please, my lord, we confirm what Advocate Mnisi has said insofar as what he has communicated regarding the involvement of Brigadier Gininda. Brigadier Gininda did take the matter up with Mr. Tebengu, the head of prison. That was in early August, my lord, and Brigadier Gininda then sent the following message on the 12th of August. This is the message that Advocate Mnisi has referred to, and we'll just briefly put it on record. He said he spoke to Mr. Tebengu, the head of CMEX prison. He maintains that there are security issues around accused number 3. He says his application was disapproved due to such security issues, but Advocate Mnisi says they haven't received feedback on the application that was relaunched, but this is what Brigadier Gininda could establish that
Where's a copy of the letter
yes,
stating such refusal, if any?
yes. We haven't been
We don't have it.
yeah, we were not finished with the letter, and he mentions in this message that Mr. Tebengu says he cannot take the matter further than that
Is it?
because of these security issues. And this is where the matter is, my lord. And in the message, Brigadier Gininda indicates that the only way of addressing the issue is if Advocate Mnisi brings a separate application in another court so that all these issues can be ventilated. Advocate Mnisi did, in his address this morning, point to the fact that accused number 3 is impecunious and that he will not be in the position to fund such an application. We are therefore, my lord, at a dead end. Our suggestion would be once again that Mr. Tebengu will be summoned to court to come and explain these issues himself, and we can then take it from there, my lord. As far as Section 173 is concerned, we don't think of the Constitution. We don't think that is applicable here. It merely refers to the development of common law,
Okay.
and that the issues that have been raised don't really fall under Section 173 of the Constitution.
Okay, yeah, I heard you. You know what? Judge Cameron, although he's a friend of mine, I don't want to use that. We were together years and years in Johannesburg. He's now occupying that position. What is it?
Yeah, I think he's like the head of prisons. So, yes. Oh, the inspecting judge. Sorry, the inspecting judge.
Yeah, of prisons.
Inspectorate, yes.
Yeah, the other day I was in the party which was delegated by the JP to read some of the provisions in the Constitution. Sorry, not the Constitution. In the Criminal Procedure Act, apparently Section 71 or 76, 77, 78, according to my brother Cameron, they make it possible in the exercise of those sections for prisoners, so-called prisoners, to be inhumanly treated. That's how he put it. The other day he was on TV saying that. Me, what I can do, I can phone him and invite him to this court. That's the best I can do. And then Mr. Mnisi and others who are so inclined can present your client's complaints to him, and he has to determine whether in fact they comply with the law. Mr. Mnisi says they don't comply with the law. That I can do. Instead of wasting time and bringing applications, let's go to the person at the top who sees to that. Unless he says, look, I can't do you that favor, Rata, fine. But I could give him a ring and say he must come here.
That's another position.
In as much as the state is actually not a party to this, but the state is wrong in saying that Section 173 is not applicable. Section 173 says about the court regulating its own processes. It does not only speak about the common law. But nonetheless, my lord, I think, but the court is suggesting under the circumstances, even if Judge Cameron, the Honorable Judge Cameron himself is unable to come here, I think they work as a group there. They might delegate maybe somebody very neutral to come and attend to this issue, probably to then have to come to
no,
the
but fellows told me that the other guys say they don't want to be involved. You must bring an application because they can't take this matter any further.
No, but that's the thing, my lord. That is the thing. This is coming from Mr. Kininda. Who is Mr. Kininda within the context of DCS, Department of Correctional Services? Because it's just the police. He cannot prescribe to the DCS on what processes are they supposed to be following.
Yeah, fine. I'm offering to speak.
This is a further perpetuation of what I'm referring to as a lynching.
I'm offering to speak to the head of
Yes,
the
my lord.
inspectorate of all the prisons in South Africa.
Yes.
And then give him these facts. And I'm inviting him to come here. I don't know, it's in Cape Town. I know he stays in Cape Town. If it's possible to spare a weekend, he must come here.
That will be appreciated, my lord. But quickly just wait with accused number 3 because this is a note that
Yeah,
is sent
fine.
me. Yes.
What do you think, Mr. Balui?
Yeah, well, we do...
Who's the judge next door, by the way?
support that approach.
The lady?
Ejele.
Yeah,
Ejele.
the one.
Ejele.
Yeah, we can even call it. We were sitting, myself, Jalele, Masopa, and Fori. We're handling something similar to this, to say that we actually suggested that the Criminal Procedure Act must be amended so that if a person comes to court and a judge makes an order that they should be treated at any mental hospital in South Africa to determine whether this person is mentally in a state to understand the proceedings, or if he is declared to be a mental patient, president's patient, that after 30 days of such an order, he must be brought back to the judge who originally issued that order, so that the judge can inspect the file, which contains the examination or the treatment which was accorded to this detainee, who is declared to be a state president's patient, and to see when will he be okay to undergo further treatment. Because according to Judge Cameron, there are some people who are incarcerated for years without any comeback from some of the psychiatrists who are treating them. He quoted a case of about a year or two of a person who just sitting in jail. So he ceased with this type of stories.
But regarding that aspect, my lord, normally what happens is that the head of such a mental institution would periodically furnish the Director of Public Prosecutions, who is the curator ad litem, with reports. And if, based on the response of the patients to treatment, if the patient should be reclassified, the head of the mental institution will then bring or request the Director of Public Prosecutions to bring an application before a judge in chambers for the patient to be reclassified.
Yeah, I've done
or
those applications.
be conditionally released.
Yeah, I've done those applications for years and years and years, where there is a reclassification, whether this person is improving.
Yes.
Because if he is declared to be not compus mentis, then he can't be charged.
Yes.
But
So that there is a recourse
that's it.
for such.
But then they say the department doesn't do anything about it. Nobody cares. So these persons, they just sit and sit and sit and sit. So Judge Cameron is busy with some of those cases, and he says, in his view, some of those cases are not being expeditiously handled, and consequently there is some inhumanity which creeps in the treatment of the inmates who are declared to be having mental problems.
In this division, that doesn't obtain, because, as I say, we do from time to time receive requests for the reclassification.
So, yeah, in any case, you have to be patient, because now is the last day of this. I can only speak to the judge today or tomorrow and ever, and then I can report back, but you guys are not going to be sitting. Have you agreed? You're not sitting?
Yes, I was told by my colleagues that they prefer not to sit.
2 weeks. Is it how many weeks?
Yeah, 2 weeks. We resume on the 7th of October.
So me, I can report on the 7th of October.
There's a further instruction, man,
Yeah.
I'm getting from Mr. Mncube when I consulted him, that once again,
Yeah.
Mr. Kabengu told him that apparently there's a letter which he has not been shown, to the effect that, the import of that letter to the effect that he needs to complete this trial because it's a high-profile case, whilst he's seated in a solitary confinement.
Where's the letter? I don't have the letters.
That is the thing, my lord. That is the thing, because we've been requesting the reasons why he's been held in solitary confinement.
No, fine, I understand.
They don't do that.
Okay, so how is the way forward? What should we do? Because
you, my lord.
this is the last day.
Yes, I think, my lord, what the court has suggested, I'm not even so sure whether Judge Cameroon will be amenable to come here.
Yeah, I
But
don't
in-
know.
But in any event, that he himself is unable to come personally, I think I will
And delegate somebody.
employ him to delegate somebody neutral to come and investigate all the shenanigans that are happening there in ECS in respect of accused number 3, my lord. Because this situation cannot
Yeah,
go on
fine.
unabated. What kind of a situation is it that somebody is told you can stay in solitary confinement up until the finalization of the case that you are involved in, because that is a high-profile case? This is actually not a high-profile case. It's just like any other case where a person gets shot and killed. We're busy with evidence here. But the person is told that you have to stay in solitary confinement, just stay there and be subjected to this torture that we want you to be subjected to up until the finalization of your case. It's very bad. It's very bad, my lord. That's
So
what
we
I
agreed
can
that
say.
I should report back on the
On the
7th of
Thank you.
October. Okay, fine.
Uthi-ke Mr. Ncube umehluko kodaba lapho uzoxhumana-ke nalokho okuyena-ke ujaji ohambe ebona amajele nezimo ukuthi iboshwa ihlala kanjani. Mase siphinde sibuya-ke ngazo i-7 lezo ila manje esezobuya khona-ke nombiko ukuthi-ke bakhulume bangakuphi-ke yena nalo nojaji lowo uJudge Cameron.
Okay. Yes, you're still under oath, Captain.